Okay, I see green. I am live. Okay, that's good. Excellent. Hello, everyone. I'm Leonard French, your favorite copyright attorney. And I know that I'm a week late or so, or more, on videos that I owe you. So I thought I'd do something a little special, and I would try to live stream this for you. What am I live streaming, and how am I going to do this? Well, that is a good question, and we are going to answer that together. Um, myself a little small. I thought today we could talk about. I want to make that blue. The James Romine lawsuit against Mr. Jim Sterling, also known as James Nicholas Stanton. Doing here. We have actual audience. Hello, audience. Thanks, guys. I'm glad you're watching. Okay, so we all know that our plaintiff is Mr. Romine. I thought we would take a little look together at this lawsuit that he filed. Before we start there, though, wait a second. Is my See, this is the problem that I'm having. My Chrome, my Chrome browser does not like to show up once I put the Adobe window on top of it. Right. See, black, 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 black. One sec. There we go. Okay. So, first place that anybody can start if they ever want to know anything about any case is by going either to the Pacer case locator, or here I have gone directly to the Arizona CMEF system, case management, electronic case filing. There's some buttons across the top here that you can use to run queries. When you're an authorized filer, there are more buttons here. As you can see, I am not an authorized filer in Arizona. So the case is called Romine versus Stanton, only because it's James Romine, not Digital Homicide, and it's James Stanton, not Jim Sterling. People use pseudonyms many times, not good for me. But to get information on the current status of the case, first look up here. Date of the last filing would be October 11th. I was actually kind of hoping that there would be some update within the last month or so. I guess it's not quite the 11th, within the last month, so that I could report that we had a ruling of some kind, but there's not. So we'll go over what the status of the case is right now. I'm going to make myself a little. Okay. So this is the U.S. District Court for the District of Arizona. That means there's only one district for the whole state, probably because there's not enough of a population, or only one big city or something like that. For instance, this case is in Phoenix. The status here shows us that our plaintiff, where he lives, how to contact him, and our defendant and who they're represented by. Our plaintiff, of course, is pro se, meaning representing himself. Then down here, the docket starts, and this is the docket or the record that attorneys will refer to as the core of the. We're creating a record. We're putting evidence and testimony and legal procedural documents onto the record, and we're going to fight over the contents, not only the contents of those, but what's allowed to be in those. So the record is everything. And so the record starts with the filing of a complaint, usually. You don't always have to file a complaint to start a matter. In some states, you can file a writ or a request to the court and start a certain kind of procedure that way. So Mr. Romine starts by filing a complaint. Bring up, hey, it works. Out a little bit. Okay, so he has written his own complaint here, so if I look ever so slightly confused every once in a while here, for example, he's started by listing the parties to the complaint. You do want to list the parties to the complaint, but there's usually a slightly more introductory paragraph before you jump in, but okay, he can jump right in. He's citing diversity jurisdiction. He has to choose his court wisely. Which court are you going to file a complaint in? It has to be a court that's allowed to hear the case. You have to be allowed to file a case in that court. So, for example, if the case here, which appears to be filed in Arizona, if he filed it in North Dakota, and North Dakota's got nothing to do with any of this dispute, the North Dakota court will eventually kick it out. So he's listing himself as a resident of Arizona, and Jim Sterling, or James Stanton, as a resident of Mississippi. Uncertain. The defendant is a citizen, yada, yada, yada. He cites venue then, jurisdiction and venue using international shoe, which is a standard case to show when a defendant has the proper contacts with a venue or jurisdiction that will allow a plaintiff to reach them in jurisdiction through a lawsuit. Oh, the defendant sells merchandise. The defendant with these sales establishes minimum contacts. The defendant charges a subscription fee. On Patreon, there were 4,000 subscribers, some of which must be from the state of Arizona, causing periodic financial contact, therefore there's minimum contacts. Cites another case, Calder v. Jones. I'm not entirely familiar, but excess of $2 million in damages is something that apparently allows him to reach. I don't know if there's really $2 million in damages here, but that's not up to me. They said if two or more persons depriving rights or privileges, case of due care. Okay, so he cited another federal law here. 1985, I'm not sure what section, if that section can be used that way, but that might be something for that we'll see later. And then I think that's just basic diversity jurisdiction, in excess of $75,000 in damages. The parties are different states, and this is root beer. Not that it, it's just, I'm telling you it's root beer. Anyway, a mountain controversy, here we go. All he has to do is actually plead that it exceeds $75,000 at this point, but he's going to say that it's $10.7 million. Complaint. When the defendant falsely accused the plaintiff and caused damage to reputation, damage to product, loss of product, yada, yada, yada. These statements have been made in reckless disregard for the duty of care that all United States persons are legally required to follow. And then he goes straight to the Jimquisition. Jimquisition. Wow, say that 3 times fast. Jimquisition article. For the purposes of the complaint, the defendant's Twitter feed will be referred to as tweeted. That's cute. The plaintiff's business partner, Steam Valve, will be referred to as the distributor. Okay. Yes, the distributor who no longer hosts them, by the way. The plaintiff took direct damage through the use of his personal name via multiple postings of false statements in regards to claims of impersonation of ECG Games, a Polish company based out of an apartment in Poland, on Twitter and the Jimquisition. I did get it right. By the defendant. So far making almost no sense. Let me tell you what the big mistake he's making already here is. As in the first 5, 6 pages of this thing, does anyone have any idea what he's talking about yet? No. That's what I meant in the beginning. You should have kind of an executive summary. We don't call it an executive. I guess you could use executive summary, and a judge today would acknowledge it. But generally, the flourishing legal language that we use, um, you would still have an introductory paragraph, a statement of the case, a summary of the case, something like that. The more reachable that is, the more your judge will be now in on page 7 going, oh, I really want to see what's going on here. But there's nothing here so far. September 24th, defendant states, libel per se, it's also worth noting that Galactic Hitman's artwork has been taken from elsewhere, just like the initial artwork from the Slaughtering Grounds. A link was provided to DeviantArt. The initial Slaughtering Grounds art was not taken from this site. It was a free upload to a wallpaper site that was a derivative work, which was then discovered, and the artist did not have. So it was taken from a site, just maybe not the site that he called out. The article falsely states that the plaintiff used an image that the plaintiff did not have rights to. After the initial burst of 10,000 views, the defendant posted a modification that maybe the plaintiff did not steal it, but the damage, especially in the context of the rest of the article, can be seen in the comments section. Okay, so here on page 7, we finally get to something where he says, here's what Jim Sterling said. This must have been stolen or taken. I don't know. This says taken. Is taken stolen? Is taken copied? Is taken taken doesn't mean unauthorized copying. I don't know. Count 2, libel per se. Here we've seen it lead to potential legal trouble for folks who've rebranded and accidentally defamed a completely different studio. The defendant claims that plaintiff has defamed a studio which is false and tarnishes plaintiff's good name. The trade name of plaintiff was plainly visible on the developer account since its creation. I really have no idea what this is about. If I'm a judge reading this, and a lot of judges have almost zero technology experience, and remember, our judges in Arizona here, which might not necessarily be a hub for technology litigation, I have no idea what this paragraph means. Could I figure it out? Like, yeah, could I take 10 minutes here and figure it out? Sure, no. The defendant states in the article, apparently you don't need to prove your company's legitimacy or existence, yada, yada, yada. This is misleading. Again states, it has a Twitter account which prior to now has no history of mentioning either Devil Share or Galactic Hitman, 2 games branded under ECC. At no time did plaintiff attempt to imitate ECC games. Okay. Again, these are interesting allegations that, actually not terribly interesting allegations, but they're allegations that a judge will have to adjudicate at some point if the judge feels like there's any kind of anything here. So he basically quoted everything he didn't like that Jim said and then turned it into, this must be libel. Is it libel? I don't know. Some of this is definitely not. Anything that's an opinion is definitely not libel. The parts of defamation are that you have to prove that some untrue statement was made in a published way, that people saw it, and that there was actual damage that was a result. The hardest part really is the actual damage, because you have to prove convincingly that the damage is connected to the thing that was said and not one of a million other things that was happening at the time. According to this email, the ECC Games is pursuing legal action against Digital Homicide for using its name. Not enough popcorn on Earth. The statement shows that false statements as entertainment for the defendant's viewers shows the false statements as entertainments for the defendant's viewers so that defendant can profit from it via... Man, this guy could really use a decent attorney to make sense of this for the judge. Okay, so we've got some fairly incoherent arguments here. A patient judge might allow Mr. Romine to clarify all of this. How far are we through this? Most of the way through this. Not make this a 3-hour video. Relief demand. Full reimbursement for lost product value. $19,000 per product, 12 products, 5 years, 1.14 million. Half reimbursement for depreciation product value for 5th through 10th year, 570,000. Loss of advertising and 50,000 keys used to advertise lost products, 51,000. 4-month loss of key access to existing products. Happened there. Get to that. 500,000. Emotional and financial distress, 500,000. Long-term costs, 3 million. Time loss, 800,000. Punitive damages, 5 million. Apologies. In place of every offending article, for a period of no less than 5 years, an apology video in the primary video location on the defendant's channel in front of... Okay, so I'm sure he means apology. In realistic terms, it would be more like a redaction or a credit or a, an admission of guilt or something like that. I don't know if you can make someone apologize. Certainly someone could agree to apologize. See, these are, I'm going to zoom out a little bit here. Receipts for things. And he says something like, the assets are all store-bought, they're both hideous to look at, interactively generic, unfinished, and broken in some significant way. That's an opinion, in my opinion, and that's not an actionable defamation statement. If he's saying, I have looked into it, and it's a fact that these were stolen, that's one thing. Maybe if he just says, I think these were stolen, and not if you say I think, that's still an opinion. But if you, these statements don't seem to be, so if he says they're store-bought, for example, what if they're not store-bought? What if he got them from a free website and they're not store-bought? Is that a difference? That is a legally recognizable difference? I don't think the judge is going to agree that that's libel because he said they were not store-bought. So keep going through here, try to find the interesting stuff. When you can name yourself literally anything on Steam, it's impossible to know who is a legitimate developer and who isn't, as we've seen in the case of Faker ECC. Apparently, you don't need to prove your company's legitimacy or even existence, since it's all based on usernames. Either we've seen it lead to potential legal trouble for the folks who rebranded and accidentally defamed a completely different studio. Okay, so the question then becomes, is this both a defamatory statement, and then was there actual damage? Did you, the viewers, the users, the gamers, the buyers, stop buying Digital Homicide's games because of this? He's going to have to prove that, and so far I just see a bunch of allegations. Now this is just a complaint, but I would expect him to have something in here to prove damages. The popcorn on Earth is a funny... I just got an email from ECC Games saying that they're not the ECC Games Digital Homicide named itself after. That's weird. Okay. Some comments on the cat simulator game. Or cat simulator. Here we go. 3 white arrows express addition of products to the submission stage by every click counts and the plaintiff's other trade name. This is initial standard product staging before being in. Okay. The man could not be less clear, could he? And then what's, so this is just his cover sheet. So, let me bring this back up. Our docket here. That's the complaint. That's his basic complaint, which, wow, is unbelievable. If I was, yeah, the popcorn on Earth comment is appropriate. If the man had these real claims worth $11 million, let's say, okay, anybody just take a step back here. If you had $11 million, you'd want to keep it, right? You'd want to protect it. You'd want to do something to make sure that you would always have that $11 million. You'd want to, put it in the bank. You'd want to, how do you know what to do? Okay, so maybe there's the bank, but then there's also these investor guys, and then there's the stock market. How in the world would anyone know what to do? Would you go on YouTube and watch a bunch of videos? Maybe you don't have time for that. You've got $11 million. You want to go, play with it, right? You'd talk to an expert. You'd go hire an expert. And I'm not even shilling for attorneys here. I'm just saying if you have money, you want to talk to somebody who knows how to handle money if you don't know how to handle money. Here, he has a legal complaint that he is saying is worth $11 million. If he actually believes in his heart of hearts that this legal complaint is worth $11 million, why in the world is he doing this by himself? No one should do that if they have that kind of claim. That's the first red flag to me that says that either he doesn't believe he has the legal claim or no one he's gone to believes he has a legal claim because he is filing such a terrible complaint all by himself. So then some other things happen after you file a complaint. Here he's requesting electronic filing access. That's pretty normal. Any one of us, pro se or not, would be given that upon being given permission to file in front of the court at all. Filing fee paid. Usually, I think it's $400. Yeah, right up there, $400. Summons issued. The summons is the legal document that starts the defendant's side of the thing. When you file a complaint like this, there is no further activity that can be completed against the defendant. Well, that's not entirely true. Different kind of case, though. When you know who your defendant is and you don't have any other special circumstances that are just not in the scope of this video, you would, excuse me, you'll get a summons from the court, and the summons is just your notice to defend, that notice of here's your 21 days to respond, what rules apply, what court you're in, that sort of thing. And then it's up to the plaintiff to either hire somebody or know the rules and follow the rules and go into court, or excuse me, and go to the defendant's location and do some more of that. Go to find the defendant's location, and properly serve them according to the rules of civil procedure. Usually that involves handing them a copy of the complaint, hence the you've been served thing that everyone now uses for everything else. Clear these out that I hope you're not seeing. Okay. Service executed, meaning that the service was completed successfully. The defendant either signed a waiver of service or an actual process server person handed them the document and will testify to that or be prepared to testify to that in court. In lieu of that initial testimony, they put a document on the record that says that they served them properly. How you guys doing? Okay, good. 48 people watching. Sweet. Okay, so first motion for an extension of time. This is a very typical move. This is coming from the defendant's attorney. This is coming from Jim Sterling's attorney. Very normal to ask for an extension of time. There's normally only 21 days to respond, 3 whole weeks. And 3 whole weeks to get on an attorney's calendar, especially a busy one, that can be difficult. So oftentimes one of the first things we'll do is make a motion for an extension of time, get 30 more days or so to respond to the complaint. In this case, instead of responding with an answer, and it always says here, motion for time to file answer. When I file them, I like to call it a response to the complaint, but it's just a personal preference. Anybody can call it whatever appropriate term they want. But it's really just any response. So you have to have any valid legal response, which would be either a pleading, which an answer, or a motion for a dismissal, which is what they did here. So consent motion means that okay, so first he filed a motion for an extension of time, and then there must have been contact between Mr. Romine and Attorney Hartman, and there was consent for an extension of time. It looks like it will be 30 days from April 5th. And then somewhere in here, what did he do? He filed an amended complaint. On the 13th, James Romine, pro se, filed an amended complaint. I have the amended complaint here. So let's see what he filed first. Maybe I don't have the amended complaint. Let's see what he amended. Let me grab this. All right, it looks familiar. Wait, why? Only the interface was zooming. Let's use these zoom buttons. There we go. Okay. So this looks remarkably similar to the old one. Oh, he's raised the amount in controversy to $15.5 million now. Aha, aha. See, it's almost magical, as if someone heard me. I know, I know. So now we have a libelous statement the plaintiff asserts. It looks formatted properly. It almost looks like someone figured out that they had that they weren't doing a great job. And so now we have underline, see attachment B, see attachment C. All right, that's great. So now if I'm a judge, I can put these things side by side on monitor or have my clerk print them out and look at what is he talking about. I am not looking through this to see what change of substance. I think it looks like it's the exact same information. 77 pages. Okay, and then, oh, okay, and then here's the exhibits again. Oh, in much higher quality. That's much better. Okay, let's save that. What document number was that? 9. But it got stricken right away. What does that mean? Go back here. Can I? Yeah, this is why we were zoomed in. There. Read that. Okay. Can you guys hear me? You guys can't hear me? Uh-oh. I lost my audio. Shit, let me look. Hang on. Yeah, I got, my meters are going here that I got audio. Oh, okay. Thanks, guys. It kicked out on me before when I was doing my test, so I thought maybe it kicked out again. All right, so the amended complaint got stricken because you're not allowed to just do that. You have to file a motion. You have to get permission from the judge to file an amended complaint. Here, you can look at Federal Rule Civil Procedure 15, and best. Okay, so let's take a moment here. There's multiple rules of civil procedure. When you're an attorney or just a pro se party filing things before a judge, you actually have to follow several rules of procedure. First, there's the substantive law. That's not a rule of procedure, but there's the substantive law. You have to know the underlying law that you're working with so that you know what procedure may apply. In this case, we're working with civil law. Copyright is a civil law. So we start with federal rule of civil procedure. Copyright is a federal law. So we'd be in the rules of civil procedure. We'd be in the federal rules of civil procedure. Then there is the court's rules of civil procedure. In this case, the court cites local rules. And then what the judge does not show on here is that there's actually, each judge has their own individual rules of procedure. Now these are kind of cascading. These are like an upside down pyramid. The federal rules take precedence over the local rules, take precedence over the judge's rules. But within the wiggle room inside those rules, the local rule may say you need to have these margins, you need to have certain things done 7 days ahead of time. And the judge's rules may be, here's how you format things to me. I want to see this in a complaint, Arial or Times New Roman, 12 point, that sort of thing. Some judges will give policies about bringing witnesses or whether they're dual video conferencing. So it's really helpful to look at all these rules, but it's a lot to do. If you ever wonder why attorneys have so much to do, it's because we have to know everything about all of that, and we often can't keep those things in our heads. So we have to look them up and make sure we're following them almost each and every time, unless it's something that we're doing the same way over again. When we do that, we develop a checklist to make sure that we don't make mistakes. So back to this. Immediately, in 2 days, the judge ordered the striking of the complaint. Let's see what he had to say. On March 4th, this year, 2016, Plaintiff Romine filed a complaint. A party may amend. Once, as a matter of course, within 21 days after serving it. In all other circumstances, absent the opposing party's written consent, a party must seek leave to amend from the court. Although the decision whether to grant or deny an amend is in the trial court's discretion, yada, yada, yada. Policy in favor of allowing amendments is subject to limitations. After a defendant files a responsive pleading, leave to amend is not appropriate if the amendment would cause prejudice, or if it's sought in bad faith, is futile, or creates undue delay. Here, defendants have not yet answered plaintiff's original complaint, but the period in which plaintiff could have amended has passed. So, local rule requires the moving party for leave to amend a complaint to attach a copy of the proposed amended complaint. Okay, so he also has to attach a copy of the proposed amendment. Okay, so this part starts to get a bit confusing. There's a bunch of stars here. Follow me for a second. Some of these things got logged on the docket out of order, I think. I have not seen this typically done, but the docket, the clerk can go in and correct things on the docket, and this appears to be how they've corrected things. May 4th of this year, there was a motion to dismiss that was filed by Jim Sterling's attorney, Hartman. That violated the excessive page rule, and so they had to go back and add a motion to exceed the pages. And then it hit the docket. So here, 12 and 15 should be the same thing. Okay, so let's look at one of those. Here is 12. Motion to dismiss for lack of standing, lack of personal jurisdiction, and failure to state a claim. Those three things are very specific, allowable motions to dismiss. The Rules of Civil Procedure, Rule 12, allows for motions to dismiss, and 12b-6 is the most wildly used of them. Lack of standing, lack of personal jurisdiction are also very common motions to dismiss. And you're going to see a little bit of a difference here, I think, between the way James Romine does things and the way Attorney Hartman does things. Can everybody see that? Okay. All right. Defendant James Nicholas Stanton moves to dismiss the complaint brought against him by plaintiff James Oliver Romine Jr. based on plaintiff's lack of standing as an individual to bling claims to bring claims on behalf of his Arizona limited liability company, Digital Homicide Studios, and 2, a lack of personal jurisdiction over defendant in Arizona, and 3, plaintiff's failure to state a claim for defamation. This motion is also supported by the attached declaration of James Stanton and exhibits thereto. Table of contents. So if I'm a judge, now I can look through this and go, what am I about to read? I'm about to read a background, why the plaintiff doesn't have standing, why the court lacks personal jurisdiction, why defendant has failed to state a claim for libel, and the conclusion. I've in 5 seconds now, I know what I'm about to read, and my brain is primed. No one ever really reads the table of authorities, but if you ever needed to go back and look them up, it's a good idea to put that in there. Also, the court sometimes requires that. Just as restaurateurs do not like negative reviews on Yelp and movie studios do not like thumbs down movie reviews, plaintiff's complaint is rooted in his unhappiness with a negative review by defendant James Stanton regarding plaintiff's company, its video game products, and its business practices in general. In each of these cases, expressing an opinion about the business of another is protected speech for which libel cannot be found. Mr. Stanton is a video game critic, pundit, and entertainer operating his business under the pseudonym Jim Sterling. Declaration of Jim Sterling. Oh, sorry, that's a citation. Mr. Stanton reviews video games online and discusses current issues surrounding video games, often advocating for customer rights and admonishing decisions made by large game manufacturers. He distributes his commentary and criticism through a weekly YouTube video series, The Jimquisition. Mr. Stanton also operates the Best of Steam Greenlight trailers, where he watches and comments on poorly made video games or games that have been sold using unaltered, pre-purchased assets, which he has coined the popular term asset flipping. He also plays and reacts to different games released on Steam, a video game distribution network. Let's stop for a second. You see how clear, if I'm a judge and I have no idea what Steam or video games are, I'm still here. I still know what's going on. I understand what the dispute is here. And I'm already in my mind going, I understand, what Mr. Romine's on about now. But I'm understanding it better from the defendant's perspective. And that's not good for the plaintiff. He also plays and reacts to different games released on Steam. Mr. Stanton also produces itch.io Tasty. I have no idea if I'm pronouncing that right. An online channel where he plays and comments on various video games available from the game distributor itch.io. Mr. Stanton also produces Nip, yada yada yada. Mr. Stanton expresses an interest in social issues through his work, often speaking in favor of more diversity within the game industry and its products. Mr. Stanton provides all of his services from his principal and only place of business in Brandon, Mississippi. Mississippi. Plaintiff James Romine is a citizen and resident of Arizona. Plaintiff and his brother Robert Romine reside in Yuma and are managing members of Digital Homicide Studios. DHS is a video game developer that has distributed its games through the Steam service, some of which have been reviewed online and sometimes unfavorably by Mr. Stanton. Mr. Stanton posted a first impression video of his unfavorable review. In response, DHS reposted Mr. Stanton's video with subtitles, responding to and refuting Mr. Stanton's commentary. Afterwards, Mr. Stanton posted a rebuttal video. Thereafter, this sounds familiar, didn't I? I talked about this. Thereafter, DHS responded with a copyright infringement claim and a takedown notice to the website hosting company. The issue was resolved in favor of Mr. Stanton, and the video review remains online. However, DHS remains unhappy. In a renewed effort to disrupt Mr. Stanton's business and quell his commentary, Mr. Romine filled the present lawsuit containing 10 separate counts of libel per se and libel per quad, and seeking over $10 million in damages. Plaintiff's libel claims are rooted in online commentary and criticism by Mr. Stanton concerning... Okay, so this is starting to get into the rebuttal is just going to be that it's not libel. Defendant moves to dismiss on three grounds. The alleged libelous comments, statements about DHS and its products and practices are not Plaintiff Romine, who is the only manager of DHS. Thus, as an only manager of DHS, Plaintiff Romine lacks standing to pursue these claims. So he's saying that because the statements were about digital homicide, he can't sue as James Romine. He would have to sue as DHS. So I wonder if we're going to see later on him trying to amend the complaint to add a plaintiff, digital homicide. Second, Mr. Stanton is not subject to personal jurisdiction in Arizona because he has not had sufficient minimum contact. So we're going to see another international shoe argument here. International shoe is one of the minimum contacts cases that governs jurisdiction that we talked about before. So we're going to see a bunch of references towards it and its supporting cases, supporting precedent. Mr. Romine is going to be citing all the ways that that Jim Sterling does business with Arizona, and Jim Sterling is going to be citing all the ways that he does not do business with Arizona. I could see it both ways. If you're making YouTube videos and those YouTube videos pay you money, you're making articles and posting those articles online, and people come and visit your website and the advertisers give you money, is that interstate commerce? And does that create enough of a contact with Arizona and the customers that you have in Arizona that those customers can expect to sue you for things you do on that channel that you do in Mississippi, but they watch in Arizona? That's a good question. I don't know the answer to that question. My gut reaction is no, that you'd have to do something more. You'd have to somehow almost directly cause something, not just advertise on the internet that people go to. And then do you get into the argument about where is the server where is YouTube's server? It's in California. So do you, or is the server, or did your content come from a content distribution network and was that in somewhere else? That's a tough question. All right, finally, the alleged libelous statements are protected commentary and opinion that are either not capable of being proven true or false, and if proven false, are not actionable because the statements are incapable of conveying a defamatory meaning. Okay, first, plaintiff does not have standing. A limited liability company is a legal entity that is separate and distinct from its members. That's correct. Anyone who's not familiar with an LLC or corporation law, basically, corporations are subject to a different set of laws of governance and all that. They have to have their own capital, their own money. They have to have their own insurance. They have to have their own assets. Usually there's a board of directors or a person or more persons acting as a director or directors. They have to file separate taxes and things like that. And so they are considered legally a separate entity. Huge topic for many other videos and much more research if you're interested in that kind of thing. Accordingly, only Digital Homicide Studios can assert claims for damages allegedly incurred as a result of defendant's conduct. So even if Digital Homicide, even if even if the statements are considered defamatory, after adjudication later on down the line, James Romine doesn't even have the right to bring the claim on behalf of DHS by himself without bringing DHS into it. And as we saw above, there's no DHS attached to this yet. We'll see. Maybe there will be. Accordingly, DHS is the proper party to assert any claims against defendant, and plaintiff cannot do it himself. A plaintiff must assert his own legal rights and interests and cannot rest his claim on the relief of legal rights or interests of third parties, and then cites a case. So this is a very good method of legal writing. Attorney Hartman here starts by showing the judge what the issue is, then showing them what the rule that is being cited is. The attorney will then analyze how that rule applies to the statement or issue that was just made. So in the prayer for relief, Mr. Romine seeks full reimbursement for 5 years, yada, 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 yada. Mr. Romine, sales of these games are made by DHS and not Romine. So that's the analysis part, and then there'll be another conclusion or another issue. Mr. Romine cannot rest his claim for relief on rights of DHS and damages sustained by the company. Therefore, it should be dismissed. So it's a very, very strong way of legal writing, is to put that issue first, the rule, the analysis, and then a conclusion. There's a couple variations of that where you might restate the issue at the end, sort of like they've done here, but you get the idea. It's a very strong method of legal writing. You almost can't go wrong. It helps you organize your thoughts as well. So second, the court lacks personal jurisdiction over the defendant. To establish personal jurisdiction over a non-resident defendant, a plaintiff must show that the forum state's long-arm statute confers jurisdiction over the defendant and that the exercise of jurisdiction comports with the constitutional principles of due process. Wow, okay, so that's a lot. So you must establish personal jurisdiction, that the court has the right to drag James Sterling Stanton into court. In this case, he's not a resident. So how would Arizona have a right to drag Mississippi resident James Stanton into court? They don't. So states overcome this by having laws about when they're allowed to, or what makes it right to hold a non-resident, an out-of-state person to some legal process in that state, in this case, Arizona. So these statutes, these laws are called long-arm statutes. The long arm of the law reaches out and grabs you. That's exactly what it's all about. In the criminal context, a warrant would be put out for your arrest. It could be put out in another state too. And either someone from your state comes and gets you, a bounty hunter comes and gets you, or you get picked up and they find your warrant. You get picked up in that state by their state police or their local police, and they find your warrant, and then you are extradited. The district attorney will make a request for extradition, and then the extradition request is granted. And then you are, or not, and then you're sent back to that state for prosecution. In this case, it's civil. There's no prosecutor involved. The prosecutor is James Romine, and you've seen how reliable that is. So the court just doesn't automatically say, James Romine can go get that state to go whatever. So James Romine has to follow the law here. In this case, the long-arm statute will say something like, here are the requirements for when we have jurisdiction over you. And then that the exercise of jurisdiction comports with due process. Well, that's always true. Due process is a constitutional amendment. It's a constitutional right. So you always have the right to due process. Real quick, what is due process? It is your right to the process of law, the procedures of law that are due to you, that are considered constitutional, that you shouldn't be adjudicated, you shouldn't be found guilty, you shouldn't be locked up, you shouldn't be deprived of your rights without this process. That process being the right to a fair trial by a jury of your peers or an unbiased judge through a procedure that gives you a chance, an opportunity to respond in a meaningful way. Arizona's long-arm statute allows the exercise of personal jurisdiction to the same extent as the U.S. Constitution. A court in Arizona may exercise personal jurisdiction over a non-resident as long as doing so accords with the constitutional principles of due process. So there's going to have to be some legal argument about fulfilling that requirement. The Due Process Clause of the Fourth Amendment, court determines contacts that sufficiently satisfy, etc., etc., etc. We're going to get into that in a moment, which is why I'm skipping over it. General jurisdiction refers to the authority of the court. Here, the court does not have general jurisdiction. A court may assert general jurisdiction over a defendant if the defendant's activities in the state are substantial or continuous or systematic. If you're studying for the bar exam, these are words you need to know. This whole part is going to be everything about international shoe. Here they're citing Doe v. Red Cross. That's probably a later case. It might have happened in the appropriate circuit. Is Arizona the Ninth Circuit? I don't know off the top of my head. Sorry, guys. I'm probably going to go a little bit quick through this because this is going to get really tedious really quick about how jurisdiction works. But the idea is, like we said before, does Mr. Stanton in Mississippi do enough business with Arizona that he has fulfilled this requirement? It all comes down to due process, but connecting that is going to be very high-level legal stuff. So here they're saying Mr. Stanton is in Mississippi, does not conduct business in Arizona, does not own real estate in Arizona, does not have an office, employees, records, accounts, sales people, or agents, never been to Arizona, no continuous and systematic contacts. Nor does the court have specific jurisdiction. Ninth Circuit applies a three-part test to determine, so I guess we are in the Ninth Circuit, whether the defendant's contacts with the forum state are sufficient to justify specific jurisdiction, another part of the jurisdiction. Under this three-part test, the defendant has to have purposefully availed himself of the privileges of conducting business. The claim, the underlying claim, arises out of the defendant's activities in that state, and that the exercise of jurisdiction is fair and is justifiable, creates justice, in this case substantial justice. The plaintiff bears the burden of satisfying the first two prongs, and then it shifts to the defendant. Can you imagine if you're a lawyer, you have to go through all of this every single time and make sure all this is satisfied before you ever file a case? This is why cases are not $200 and they're more like $20,000. Here we go on to have the argument. Plaintiff has not satisfied the two prongs of the test. The Supreme Court has held yada yada where indicated effects of a non-forum conduct were purposely directed and caused harm. Yada 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 yada. Plaintiff mistakenly focuses his personal jurisdiction allegations on the fact that plaintiff resides in Arizona, and thus defendant should have known that any damage from alleged libelous statements would be felt by plaintiff in Arizona. However, the effects test is not this broad. The Ninth Circuit has observed that Calder cannot stand for the broad proposition that a foreign act with foreseeable effects in the forum state always gives rise to specific jurisdiction. They're saying that there isn't one, this kind of act doesn't automatically give rise to jurisdiction. Tort-based personal jurisdiction torts are wrongs, are legal wrongs. Copyright infringement, defamation, these are torts. Tort-based personal jurisdiction was most recently addressed in Walden v. Fiore. In Walden, a Georgia police officer searched plaintiffs in Georgia and seized a large amount of cash. Plaintiffs claimed after they returned to their Nevada residence, Walden helped draft a false probable cause affidavit in support of the forfeiture. No forfeiture complaint was ever filed and the funds were returned. Plaintiffs filed a tort suit against Walden in a Nevada district court. The district court dismissed, finding that the Georgia search and seizure did not establish a basis for personal jurisdiction in Nevada, even though that is where the plaintiffs lived. The Ninth Circuit reversed, reasoning that Walda submitted the affidavit with the knowledge that it would affect persons with significant Nevada connections. The Supreme Court reversed again, upholding the lower court's decision. In the unanimous decision, the court found there was no jurisdiction in Nevada. The proper question is not where the plaintiff is experienced in a particular injury or effect, but whether the defendant's conduct connects him to the forum in a meaningful way. So, is there a meaningful connection between Jim Sterling and Arizona? Not, is there a meaningful connection between Jim Sterling and James Romaine, who happens to be in Arizona? So, that sounds like a pretty strong argument to me, that if unless there's more about how much Jim profits from Arizona, or how many business partners he has in Arizona, it doesn't sound like there's many contacts with Arizona. So, skipping ahead a little bit, plaintiff also asserts the defendant purposely availed himself for the privilege of doing business with Arizona by selling subscriptions. However, Mr. Stanton does not sell anything in Arizona or to the state of Arizona. He produces videos and articles in Mississippi, which his audience can choose to donate him on Patreon, a crowdfunding site. The audience is worldwide and has no specific or majority basis in Arizona. Mr. Stanton's business is supported entirely by crowdfunding, meaning that individuals voluntarily elect to support defendant's business through donations, etc., etc., etc. So he's saying that he doesn't really do business with Arizona per se. He does business with everybody, and there will be some Arizona residents, but they don't stand out as the one main primary place he's doing business with. If anything, that seems to be Mississippi. Defendant has failed to state it. Let's get this. This should be good. Defendant has failed to state a claim for libel. Defendant also requests that the court dismiss the complaint for failure to state a claim upon which relief can be granted, which is exactly the reading of 12b-6. When accepting all well-pled allegations as true, if no relief could be granted under any set of facts that could be proved, then the motion to dismiss should be granted. So the judge should look at the plaintiff's complaint, pretend things that are well pled are true, draw the reasonable inferences necessary, and then decide whether there is a case here. Now, we already know that there was a little bit of trouble just getting through that complaint. So let's see what Attorney Hartman has to say. Again, just root beer. To be defamatory, a publication must be false and must bring the defamed person into the disrepute, contempt, ridicule, must impeach plaintiff's honesty, integrity, virtue, or reputation. Plaintiff has pled both libel per se and per quad. According to Arizona law, libel and slander are classified as either per se or per quad. I'm glad that they're clarifying this, because I, for a moment, did not know what they meant by per quad. So that's a different kind of libel that we're about to find out what that is that Arizona recognizes. If a communication is libel per se, if it tends to impeach honesty, integrity, or reputation. If a communication is libelous only by considering extrinsic information, then it's per quad. So per se would be on its face, and per quad would be something you have to infer. The trial court decides in the first instance whether, under all the circumstances, a statement is capable of bearing a defamatory meaning. The jury then decides whether the defamatory meaning is in fact conveyed. Insulting or offensive statements are typically insufficient. A judge or jury will probably require that a statement be derogatory, degrading, and somewhat shocking, and that it contain elements of personal disgrace. They will not waste their time with mere slights or insults. A court may take into account material that is not alleged in the complaint. Okay, so here he's going to start citing things that were not alleged in the complaint. Context matters. A court may deviate from the general rule that courts, when ruling on a motion to dismiss, must disregard facts that are not alleged in the face. Okay. Plaintiff attached to his complaint only a few select paragraphs from the article and Twitter pages where the alleged libelous statements were made, but did not include the entire content of the pages or the surrounding pages that viewers accessing the content could not help but see. Attached to defendant's declaration are copies of those pages. So we're saying that not a complete set of facts was alleged. The article and the Twitter statements are not defamatory. When viewed with an eye on the legal requirements for proving libel, none of the statements in the article or on Twitter are defamatory. Defendant James Stanton is a well-known online video game reviewer. On November 1st, he published his first impressions of the video game The Slaughtering Grounds. Mr. Stanton noticed similarities between the later ECC Games products and the earlier Slaughtering Grounds game. Based on the similar content and artwork, Mr. Stanton concluded that ECC Games had originated from DHS but were being distributed under an alias name. Mr. Stanton also discovered that ECC Games is the name of a real gaming company located in Poland. The real ECC Games contacted Mr. Stanton to make clear to him and his followers that they had no connection with the games being distributed by DHS under the ECC Games moniker. Mr. Stanton then wrote the article about the alias ECC Games, how the ECC Games might appear to originate from DHS, and how DHS was able to distribute games through Steam using an alias that was the name of a legitimate games company unrelated to DHS, and how the real ECC Games company had told Mr. Stanton that it was taking legal action against DHS. They attached the article. It is important to note that Mr. Stanton discloses early on in the article that his discoveries and conclusions are just that, discoveries and conclusions. Quote, I cannot present everything in this article as verified fact. The statement at count 1 is not libel. So they're going to go through each of the 10 counts of libel. It's worth noting that Galactic Hitman's artwork has been taken from elsewhere. The statement is not libel. In fact, the statement is true. So it's definitely not defamatory if the statement ends up being true. No matter how damning it is, it's not defamation if it is true. There are other things it could be, not in this case. I could construct a scenario where something that might sound defamatory that later proved to be, but no, generally if it's true, it's not defamatory or anything else for that matter. You're allowed to publish true facts for the most part. It is a vague assertion of opinion that in the context of a game review and with links for individuals to form their own assessment of the artwork is not sufficient to support a finding of defamation. Does truth equal fact? I think so. In the context, the video game enthusiast reader would view this statement as the critic's opinion that the artwork in the game looks similar to artwork found elsewhere. In fact, plaintiff admits that the artwork is not original artwork, stating in the complaint, okay, yada, yada, yada. So they're going to go through and deconstruct each one of these, but the gist of it seems to be that all of this is either true or opinion, that they did talk to ECC Games. And as you can see, it's all properly formatted, which I know guys, when I was a kid, when I was younger, even now, formality and process and procedure is all, it's extra. Why do you need to have to go through that? Why do you have to put on a suit to go to court? Who cares if there's a, if your versus your, there, or if you use a typo or a comma in the wrong place, as long as we get it, right? It's distracting when someone is as trained up as a judge and they have to look at these things day after day, every day, and they see all sorts of different things coming in. It really does become a job for them to read through it all. And so when they come across something that's properly formatted and makes sense and reads properly, it stands out. And when they come across something that's not properly formatted and it looks bad and it doesn't make sense, it also stands out. But it stands out for a different reason, and the judge is going to remember that reason. I'll give you a personal example. I used to wear an earring, and I often wondered when I was in law school, would I wear this earring to court? And I asked a professor, do you think in 2011, when I get my license, I'll be able to wear my earring to court? Well, yeah, I can probably get away with wearing my earring to court. No problem, was the response. But if the judge has an issue with the earring, or if the judge doesn't really have an issue with the earring, but maybe he just has a little bit of an issue with the earring, and it's distracting to the judge, do you want that? Will your client want a lawyer that has something that's distracting the judge? What if it was a woman who was too provocatively dressed, or a man that was provocatively dressed, but you see that a lot less often. What if it was a man wearing an inappropriate item of clothing, a funny hat? These things might distract from your case. So do you really want to be that lawyer that got something that was distracting? And maybe it's only a little distraction, but what if you just needed a continuance and the judge just didn't really like you that much? Or what if you just needed a little bit of leeway and a few minutes to look something up and the judge didn't want to give it to you? If you had been nice to the judge and pleadings were good and everything, maybe the judge would. Should it be that way? No, of course not. It should be pretty matter of fact and all that. But people are human people, and that's what happens. We're all human people. The judge also, yes, I have seen that. Definitely, some of the lower court judges are a lot less formal. The magisterial district courts are definitely a lot less formal. So he goes through the rest of these statements. We could probably take another, we're already up to an hour, holy crap. We'll probably take another hour looking through just this one document, talking about everything. Conclusion, in summary, none of the statements that form the basis of plaintiff's libel claims are defamation. He recites the other two, and then the case should be dismissed. So, then I think there's some exhibits here. I'm just going to skim through these. He verifies that these are all. Okay, so this is, I'm going to back up and I'm going to read this. This is a declaration. I should not have skipped through this. This is a declaration of James. This is James Nicholas Stanton's words in support of his motion to dismiss. That the things he's attaching are true, that he's a video game critic, that he makes the Jimquisition. This looks very familiar to the other points that were being made. It's going to be pretty much a mirroring of it. And so he's making all these, why is he doing this? He's making all these statements so that he can, the attorney cannot testify. Your attorney cannot testify on your behalf. Your attorney is going to say things that sound an awful lot like testimony. On December 5th, my client was driving. But the judge is not supposed to take that as established fact. The judge is supposed to be primed now that your client is going to say these things, but the judge is supposed to remember in the back of their mind that the attorney said that, and that fact is not yet established. So this declaration then is the words of James Romine, James Nicholas Stanton, possibly notarized, maybe not. But just saying that what my attorney says is true. All those statements are true, and they're saying it in his own words here. So then, hey, Chromeworks, back to the docket. So then there's a response in opposition to the amended complaint that we were talking about 20 minutes ago. And you can see how this gets complicated real quick. This is fortunately only a few pages long. There we go. Sorry. Somebody yell at me. Defendant responds in opposition to leave to file First Amendment complaint. Defendant recognizes that the complaint shall be amendments shall be freely given when justice requires, but it should be denied. Plaintiff does not have standing, etc., etc., etc. Proposed amendments do not change and are therefore futile. So, futility, they should not be allowed to be filed. Okay? Then Mr. Romine responds. Wait, I went too far. That's the response to the motion. Here's the response reply. Didn't grab it, that's why. The plaintiff respectfully requests that the court deny defendant's motion to dismiss the amended complaint. Wait a second. This was the response. What the heck is this? As the motion is futile. Okay, so this is actually... So he's saying that the court deny defendant's motion to dismiss the amended complaint. No, I think he's asking that the court deny the motion to deny an amended complaint. No? I could be wrong. As the motion is futile, in the event the defendant's motion to dismiss is denied due to support. Somebody else makes sense of that gibberish. I cannot. We'll go on to the next thing. Okay, there's the motion to dismiss for failure to state a claim, back on the docket correctly. There's his response. And we just saw no. Here's his response. Yes, 13 pages. In regards to the declaration, the plaintiff asserts the following. The defendant states on line 19 that services are all provided from Brandon, Mississippi. Then defendant states he does not sell anything to Arizona. Attachment A1 is an image of a shirt purchased by the plaintiff with defendant's nickname on it, which was shipped to plaintiff's Arizona address. Included is a receipt by Shark Robot LLC, which is used by the defendant to distribute his goods for personal profit as a sole proprietorship. Okay. It was supposed to be continuous and systematic contacts with Arizona, not, hey, look, I can order something from a third-party company and get it shipped to me in Arizona with his name on it. There is no way to ascertain how many products defendant has purchased in Arizona or of products of defendant that have been purchased in Arizona have been sold. This provides minimum contacts, and the defendant does in fact do business. And then he cites to Ventura v. Kyle, the defendant of that case was subject to personal jurisdiction for committing acts through radio and publishing text outside of the state. Recent precedent provides for 14th Amendment rights of due process for... Okay, but what recent precedent? It is precisely the same as being hit with a car by an out-of-state resident passing through. No, it's not. And I hope you could see why, Mr. Romine. The car is an internet semi with a camera attached to its display, showing the plaintiff being run over to defendant's subscribers, which is then followed by 1,000 more cars following the defendant's lead. I get a person could maybe feel this way about it, but no one's physically present in the doing of this to Mr. Romine. And I think that's going to make a big difference to the court. Okay, then donation. Patreon donations, I guess, is what he's referring to. Provides exclusive access to, quote, $1 the minimum to get into the comments and the stream on here. Plaintiff asserts that this makes the donations an actual subscription-based service providing extra content. whether the profit earned is subscription or donation when systematically earned within the state of Arizona. He's not quite connected to the dots about how that connects him systematically to the state of Arizona. Again, having a few subscribers to a magazine, for example. What the heck is a magazine? I still don't think that would be enough. This is just an online thing, and we could make arguments about your computer has to request it from their computer, and where's that computer located? Maybe I'm just a little bit too on about the computer. Statement of fact to deny dismissal for reason of use of an LLC. The defendant has requested dismissal based on plaintiff's lack of sufficient grounds to cause action for use of LLC incorporation. Does Mr. Romine speak English? Did I assume that he speaks English? In the article, as stated in the complaint, the defendant has used the plaintiff's real name. Use of the plaintiff's name, even in modified format, Romino, does not deter the public and the defendant's subscribers from knowing exactly who the defendant is referring to. Okay. It's still a stretch. The article was not a critique on a product, but a news article reaching hundreds of thousands of consumers in the plaintiff's market. I'm going to go out on a limb here. And let me say this very clearly, this is my opinion here. I wonder if Mr. Romine does not have the blessing of his business partner to use DHS to make these lawsuits. Had the defendant only referred to the company Digital Homicide Studios throughout the defendant's publication, then plaintiff would have had significantly less impact and much less cause of action. The defendant has emphasized the plaintiff's name specifically as an attack on the plaintiff's name and person and good name. Okay. Statement facts of claim. Statement of claim has been made within the complaint. It specifically states the amount in demand and a short description, yada yada. Proof of reputation. The plaintiff is a continually advancing IT professional who has written 3 books on internet games published by John Wiley & Sons. Oh, okay. John Wiley & Sons is also, has also been known for litigating over copyright infringement. The plaintiff had intent to use this reputation as the plaintiff's right of publicity to gain additional reputation and customers on future products. Prior reputational involvement by plaintiff include IT professional at a financial institution, overseeing systems and control of over $1 billion in financial assets, $1 billion in financial assets. $1 billion, $0.02 cents. $0.02 or 0.02 cents. And systems lead in charge of system level requirement. Man, this is tough, man. Holy crap. Up to the end of 2014, when it expired, the plaintiff was CISP certified. Oh, hey, cool. Certified Information Security Professional. That's supposedly a decent, that's a goal of mine. I wanted to study up for my CISSP, but I'm not what I would call a security professional. And you need 5 years of security professional experience before you can take that certification. So what is he doing this instead of being good at his job? I don't know. Like this is definitely out of his league. The defendants catch-all claim that everything in the article cannot be verified, and then subsequently stating we can at least verify with no The defendant's YouTube channel specifically shows Truth as a reputable source for information, and as such, any false statements posted by defendants have damaging effects. Oh, this is just bad. The defendant did not take action of last clear chance doctrine to avoid damages. Okay, the last clear chance doctrine is an old doctrine. It's probably still alive in some places that says that the recipient of an injury has a duty to avoid the injury if possible. And if there was one last clear chance to swerve out of the way or step out of the way before the truck ran you over, it could lower your damages when you sue for that injury. I'm not sure how that applies here. Okay, so that's their response. That was 20, the response. Now he's made another motion for leave to file an amendment to that response and an excessive page request, and then a proposed amendment to response to defendant's motion to dismiss. Wow, okay, this is like 3 extra layers on top of this onion here. So he's filed a response, then he wants to amend the response, then he has to propose the amendment to the response because that's the judge's request, right? Then there's going to be reply to the response to the motion to dismiss. Okay. We're going to skip to that. This is defendant's reply in support of the motion to dismiss. Plaintiff does not deny that he is a manager of DHS, that DHS is the business that produces and distributes the games reviewed by defendant, that DHS is the business that is the subject of the article, or that DHS is the entity that suffers the alleged harm through alleged lost sales. Plaintiff argues that his real name is used in the article, and so plaintiff has personally suffered. That is an insufficient basis for converting a complaint that is focused on alleged defamation against DHS and alleged damage to DHS and its sales into a complaint about plaintiff himself and his personal sufferings caused by being a manager of DHS and being referred to in the article as Romino instead of Romine. It is clear from the complaint that plaintiff is asserting that claims of DHS, the claims of DHS, and not of himself, etc., etc., etc. So, as we saw from that previous document, Mr. Romine's previous response, he didn't really attack anything with any substance. He just sort of made his arguments over again. Regarding personal jurisdiction, plaintiff points to an online reseller of t-shirts. This sale does not support personal jurisdiction nor refute Mr. Stanton's declaration. The shirt purchased by the plaintiff was created, manufactured, sold, and distributed by Shark Robot. Shark Robot is an independent business. Plaintiff has not alleged that Mr. Stanton has any ownership interest in Shark Robot or any control over the company or its business. In fact, Mr. Stanton does not own or control Shark Robot. Because Mr. Stanton has no control over Shark Robot, Mr. Stanton cannot control where Shark Robot sells its goods and cannot be purposefully directing business activities from Shark Robot to the state of Arizona. I think that's a fairly strong argument, but I think we need to let the judge decide on that one. Furthermore, the evidence of a sale to Arizona by Shark Robot is a sale consummated by plaintiff himself. The plaintiff cannot manufacture personal jurisdiction in his home state simply by supplying a purchase of a product for delivery. Finally, this case has nothing to do with t-shirts or products purchased by Shark Robot. True. Here we go. Defendant argues that in Ventura v. Kyle, defendant was subject to personal jurisdiction in Minnesota based on statements he made on the radio and in a book published outside of the state of Minnesota. Personal jurisdiction was never an issue in Ventura, either because Kyle agreed that he was subject to personal jurisdiction or because he never challenged personal jurisdiction. That's true. Here's a little trick for you, future attorneys. You can file a lawsuit in violation of jurisdiction and make it the defendant's problem. Copyright trolls, thank you very much. The only reported decision in the case is Ventura v. Kyle. Personal jurisdiction is never discussed. A review of the case docket shows no motions regarding personal jurisdiction. There is no support for plaintiff's suggestion that when a statement is broadcast over radio or even the internet, that it's subject a speaker to personal jurisdiction in every state the transmission reaches. And then failure to state a claim. Plaintiff's response to the motion to dismiss does little to refuse the motion. Defendant stands by the motion and the legal arguments and cases cited therein. Plaintiff cites the last clear chance doctrine in arguing the defendant did not take proper care to avoid injury to plaintiff. The last clear chance doctrine is a doctrine in the law of torts that is employed in personal injury cases when assessing contributory negligence between a defendant and a helpless or inattentive plaintiff. So far as defendant can ascertain, no Arizona or federal court has ever applied the last clear chance doctrine to a defamation case. Wow, I was laughing. Plaintiff also cites Milkovich versus Lorraine Journal, noting that even a statement of opinion may often imply an assertion of fact. The statement, "In my opinion, John Jones is a liar," may still imply a false assertion of fact. While true, this is an incomplete analysis. The Milkovich court went on to address the test laid out in the motion to dismiss, namely that defamation can only stem from factual assertions that are capable of being proved true or false. A writer's use of loose or figurative language can determine whether the statement can be reasonably interpreted as a factual allegation. Cite some cases. First Amendment precluded recovery under state emotional distress action for ad parody, which could not reasonably be interpreted as stating actual facts about the public figure involved. Also, public figures are held to a different level of defamation, different level of standard for defamation, different duty of care. Use of the word traitor in literary definition of a union scab, not basis for defamation under federal labor law, since it is a loose figurative sense. Also, it seems to be a dictionary definition. Was merely rhetorical hyperbole, lusty and imaginative expression of the contempt felt by union. As noted in the motion to dismiss, statements of rhetorical hyperbole are not actionable, as the law provides no redress for harsh name calling. The court is not required to strain and stretch the meaning of the statements in order to unearth some. This is some good legal research this man did, Attorney Hartman did. This takes often hours to find these cases and actually find the individual quotes that go together and with some sort of flow to make your legal argument for you. But it is the strongest form of legal argument to be citing other courts' words. In summary, none of the identified statements from the article or tweets rise to the level of defamation or justify plaintiff's request that the court take drastic measure of squanching Mr. Stanton's First Amendment protections and his right to provide public commentary and critique. Yada, yada, yada. Okay. Back to our docket. That was 25. Then there's Mr. Romeen's motion for leave to file a supplemental memorandum. And then the proposed supplemental memorandum, which it looks like that hasn't been granted yet. So let's find out what that looks like. Bored yet? 86 of you don't seem that bored. Squanch! Yeah, squanch this. Supplemental memorandum in support of motion/amended motion in response to defendant's motion to dismiss the original complaint. Mr. Romeen. The plaintiff submits this motion in support. See, he's starting to get it. I think he's learning. I think he's starting to get that how this is done. This motion in support is in 5 parts and provides supporting analysis and facts to the... Wow, he has learned so much in just a few short months. How long has he been... He's filed it in March. He filed it in March, and in 3 months he has figured out to put something very basic in it. This is... Wait, I'm looking at Mr. Romeen here, right? This plaintiff. The plaintiff, yeah, okay. Sorry, I'm nuts. The plaintiff asserts that just as scruff face is used to describe Mr. Ventura in Ventura v. Kyle, oh God, he's still on. Uh, did you miss the part where Ventura v. Kyle, where Kyle didn't challenge the personal jurisdiction? Uh, in other words, so Ventura v. Kyle, Kyle let himself be held to defamation in a foreign court and did not challenge it. Here it's being challenged, so this is not what you argue. This paragraph is useless, is pointless. It doesn't mean anything anymore. There were sufficient references to tie plaintiffs to the above cases. The references could be avoided, simply stated as Digital Homicide Studios. That's not how this law works. Just because there was a way to construct a different way of saying it doesn't mean that he had to. Still trying to hang on to this, the fact that they've done damage to him personally. The victim of a libel, or like the victim of any other tort, may choose to bring suit in any forum in which the defendant has certain minimum contacts such that the maintenance of the suit does not offend traditional. Yes, this paragraph, this statement right here, that is a term of art. It is a big-ass term of art in the world of jurisdiction, in the legal world. That is not some, I can think up what minimum contacts are, and I can think up what, no. You have to go research that. What are minimum contacts? What does that mean to the court? What does it mean to a different court in each circuit and in each district? There might be elements of that have not been established in your district. I practice copyright law, and I often come across courts that have not established some new law or new way of handling certain kinds of new copyright cases, such as BitTorrent file sharing. There has been no response by defendant in regards to the subscription service, as there is sufficient minimum context related to its jurisdiction. Okay, he gets to make the argument. The judge will hear the argument. Where in the case of Hustler magazine has continuously and deliberately exploited the New Hampshire market, it must reasonably anticipate being hailed into court where there is libel action based on the contents of the magazine. Okay, I don't remember Hustler being discussed before, but that's an interesting argument. If it's true that Hustler could be brought into court based on something that was said in its magazine. Now, here's a difference, though. James Stanton doesn't send his video to you on a CD or inside of a magazine. He sends his video to you after you request it over the internet. And he sends it to your computer from a computer that's probably not even in Mississippi, although he might upload it and create it on his computer in Mississippi. And then he cites Brainerd versus Governors of University of Alberta. An alternative forum exists, but Arizona has a strong interest in protecting its residents from torts that cause injury within the state. This is also true, but they're usually referring to a greater injury or a greater kind of injury. If the defamation occurred, the false statements were imparted to the listeners and readers of Arizona. Okay? Again, he's not really addressing the status or the jurisdiction, the issue of jurisdiction. He's not addressing the minimum contacts, fair play, and substantial justice. The defense's response to the statement of claim existing within the complaint is insufficient, as the statement exists in a format provided within the pro se guide obtained on the U.S. Oh God. There was a mistaken reference in the motion in response to the defendant's motion to dismiss statement. Does that make any sense to anyone? Statement of claim is contained under jurisdiction on venue items. The plaintiff was aware of the requirements and believed the format used was sufficient. No idea what he's talking about. The defendant states that, in fact, plaintiff admits that the artwork is not original artwork. Yeah, that was my complaint, or my issue with it too, was that it was, he said something about it was taken. Well, taken does not mean theft automatically. The statement shows a lack of perspective on the actual events that took place. Again, not attacking the actual issue. It's like this. Not really attacking the issue when we want to attack the actual. You know, you love my my good animation there. My budget. And the plaintiff's partner saw free to use, he believed it meant free to use. This was a licensing misunderstanding on plaintiff's partner's side. As soon as it was discovered that there was an error, the copyright had actually been stripped by a third party, plaintiff removed the image. Okay, so Romain is gonna argue that taken means theft and he didn't steal it, so therefore it's not theft, so therefore it's defamation. How far removed he has to go here before reaching an actual cognizable claim? In conclusion, there has been no intent of wrongdoing, no actual wrongdoing, and no effort by the defendant to verify facts in communication directly to the plaintiff. Here's where it might be important to word your things properly. In conclusion, there has been no intent of wrongdoing, no actual of wrongdoing, no effort by, no intent of wrongdoing by defendant, no actual wrongdoing by defendant. He needs to say no intent of wrongdoing, no actual wrongdoing by plaintiff, and no effort by defendant to verify the facts. The statement that the defendant proposes that if the plaintiff has admitted the artwork was not original is using an improper reading of the entire passage and an improper retraction. It's not strong arguments. Correction statement by defense. In regards to jurisdiction challenge in Ventura v. Kyle. Oh, we're still on this one. Oh my goodness, we're still on this one. And this is on the 9th of the 10th page. There was a challenge to jurisdiction venue in Ventura, wow, v. Kyle. Approximately a year after the case began, after Kyle passed. That request for change was denied, although this could be due to how far the case had progressed rather than the actual jurisdiction. Yes, that's when that happens, that case does not stand for that anymore, does it? Really reaching. And then that changes the whole case. In Ventura v. Kyle, I don't even remember what the facts were, radio, so something on the radio, and then he let himself be pulled into a foreign court, right? So plaintiff Romain is trying to use that to mean that you can get to an out-of-state plaintiff. Even if Kyle had succeeded then in challenging the verdict, the out-of-state verdict, later on, then it just sends the case back to be heard in the proper venue. It does not then stand for that jurisdiction, you know, being able to pull you in because you said something on the radio. And then Patreon is not a business partner. How could he make so much money if it's not a business partner? It's also not enough contacts with Arizona. People donate to Patreon. Patreon gives Jim Sterling money. That's somehow contacts with Arizona. I don't know. I don't think so. Back to our docket. Okay, so that was number 25, I think. 28. That was number 28. Then there's a response in opposition for the leave to file the supplemental memorandum. So we just read through the supplemental memorandum, but he hasn't gotten permission to file it yet. He's just filed it as the proposed memorandum, and then and asked the court in the previous document for permission to do so. So now this is the actual opposition. This is Attorney Hartman's and James Sterling's opposition to just the leave to file, the request to file. Unfortunately, it's only 3 pages long. Defendant Stanton responds, plaintiff's motion should be denied because it is an impermissible surreply. Plaintiff merely repeats arguments already made in response, and cites new cases not within defendant's reply brief. Motion should be denied. If the court is inclined to grant the motion, the defendant requestfully respects leave to file a response thereto. Also a good idea. Order. At issue. Orders come from judges. At issue are pro se plaintiff James Oliver Romean's leave to file amendment to motion in response to motion to dismiss. Motion to leave to file excessive wow, I'm done. Motion for leave to file excessive pages and amendment to motion in response to motion to dismiss. Do we have, like, can you read this competition? And motion for leave to file a supplemental memorandum in response to I'm going to count my chickens. Defendant's motion and plaintiff's original response thereto were filed on the same day. The next day, plaintiff filed his first motion to amend as well as a motion to exceed the page limit, both in order to amend his response. Because plaintiff lodged his amended response immediately after filing his original response and defendant considered the amendment, and defendant did consider the amendment in preparing his reply, the court will grant plaintiff's first motion to amend and motion to exceed the page limit. However, plaintiff then filed another motion, number 27, after receiving defendant's reply on the grounds that plaintiff's second amendment is an impermissible, and defendant objects on the grounds that plaintiff's second amendment is an impermissible surreply and does nothing but repeat arguments made in the previous responses. The court agrees with the defendant. So it is ordered, granting the first motion for leave to file an amendment and excessive pages, and then a denial of the document we just read through, number 27, which is we didn't read through that, which is the 28, which is the memorandum that he was asking for leave to file. So he cannot file. Romean is now cut off. He can no longer file anything more with regards to this motion to dismiss. Or excuse me, the motion. Crap, I got myself messed up. He can no longer file anything more with regards to his response to the motion to dismiss. So he was granted leave to file the amendment, and so now he's filed the amended response. What is that amended response? That's document 31. And it's the same thing that he filed before. Yes. So it's what we read before with some corrections, seems like. A whole lot of mistakes, right? Like, and then, oh, he's starting to do the whole pay. Oh my goodness. He did this in the other case, in the Steam lawsuit case. Underlined whole paragraph, whole pages of things. Here's 2 pages, 3 pages of underlined statement. If you are a judge, you do not like reading that. You see this and you're like, you just tune it out. Wowza. Okay. And then here's where I'm going to disappoint you all. It doesn't actually have a conclusion yet. What we have then is a final motion by James Romine to amend his complaint one more time. Go all the way back. Here we are 6 months, 7 months at the end of September, 8 months, coming up on 9 months now. He wants to go back and amend the complaint all the way in the beginning and start all the way over. And that looks like this. Where's my cursor? I've now lost the cursor. Do you see why this video is a little bit late? Motion for leave to file. Second amended complaint. The plaintiff respectfully requests the court accept this motion. Attachment T1 shows where the plaintiff misquoted the proper code, which was believed to be US code. What? Okay. Original code was cited from Cornell University's law website. There you go. I've used it too, but you have to verify what you're looking at. The plaintiff has just learned of this discrepancy and requests to submit an amended complaint. Okay, so maybe he's not looking to amend the whole complaint. Great. I thought he was looking to start over. He's looking to go back and change what US code he cited. Okay. So that's even more disappointing in a sense, I guess. But wait, hang on a sec. Let me get my bearings here with the docket. I skipped one. See, this is skipped 32 because I had my Adobe out of order. Out of order. Second response to motion. Amended response to motion. What's this second okay, so just bear with me for a second here. What the heck is this? This was supposed to be over here. No. Okay, it's just an addendum. He's just the plaintiff respectfully requests the court accept the plaintiff's motion. He's a programmer, all right. He just copy pastes and just nests it all in there like a programmer would do, right? Instead of understanding overall what he's trying to accomplish. Okay. So then here is Attorney Hartman's response and Jim Sterling's response in opposition for his leave to file an amended complaint, a second amendment complaint. Mostly because it's futile. The motion to dismiss was filed on May 10th. A decision is pending until an order is issued on the motion to dismiss. It is a waste of judicial resources for the court to consider an amendment to the complaint. Agreed. Additionally, the motion to amend should be denied because the proposed amendment is futile. With the amendment, plaintiff seeks to replace a reference to 28 U.S.C. 4101, foreign defamation actions, with a reference to ARS 12541, Arizona statutes, that is, 1 year statute of limitation on defamation claims in Arizona. Neither statute provides a cause of action for plaintiff. There are no foreign judgments at issue in this case, and the statute of limitations is a defense to a defamation claim and not a separate legal cause of action. If that's the case, this is Mr. Romine completely misunderstands some very, very basic concepts of law. So the motion for leave to amend should be denied. And then 35. 35? I have 35 here. Hang on, I know I have 35 here someplace, right? No, I apparently don't have 35. Un segundo. So then this is Mr. Romine's final reply on October 11th. The plaintiff respectfully requests that his reply to opposition to motion for leave to file second amended complaint be accepted, as there was an error on strike through on the original document. As stated in the document, only U.S. Code 2840 was meant to be struck through. 1985 was meant to be intact. So he's trying to use these replies to correct his mistakes. That's not what replies are for. The reply is supposed to be answering a claim that was made in the previous party's response. In this case, the response we were just looking at. When an attorney or a party makes a mistake, there's a way you go into the docket and you make another docket entry, admitting the mistake and asking for a correction, basically. If there isn't an established procedure for it, you make a motion for the correction of the docket. So yes, the case is still going on, and so I thought I would take this time to open it up to questions, where I'm going to go look at, I've actually never done a live stream like this before. I'm going to go look at my the chat here on the live stream, and we'll see what you guys are asking. So if you have any questions at this point, go ahead and ask. I'll keep the live stream open for a little while, and then we'll close it down when I see y'all are getting bored and you're starting to leave. How about that? Or when I get bored. Make myself bigger. I can make myself. How do I put you up top? Drag this up. How long is this stream going to be? I don't know. How much longer do you want it to be? Do you have any questions? If you have any questions, go ahead and ask them now. I'm still trying to figure out how to make myself bigger. Camera. Edit. Oh. Myself. The year 2061, and we're still waiting for... Just join the stream, a little backstory. So to summarize, Mr. Oh wait, hang on. Chrome. What's going on with Chrome here? I've lost Chrome again. This happens when I switch back and forth between things. I bring Adobe back up and then I'll answer questions. Oh, I've just covered myself. Hang on. Doing great. I'll leave that up there. There's what I'll use as a background. Okay. See if I can make use of this chat. Is the Romines human? I am wondering that at this point. Why has it not been thrown out yet? Probably because the judge is going to take their damn time in looking at it and figuring out what they want to do with it. A topic for another video, for example, one judge got frustrated with a file sharing case and wrote an entire opinion and order in the style of well, not in the style of, but using references to Star Trek. And it was literally called the Star Trek opinion. You can search for that if you want. And there were, I'm gonna kill it, but there were, it was like to boldly go where no plaintiff has gone before or something like that. It was like that throughout the whole thing. It was really pretty good, as long as you're expecting it to come from a judge and not from a comedian. A little backstory, Matthew D, I see you're asking that. James Romine filed a lawsuit himself against Jim Sterling, a video game reviewer. The review was really, really critical. Mr. Romine did not like that, so he filed a lawsuit. But he used his own name, and he's alleging lots of defamation against his company. And so there's so far been lots of back and forth about whether he's even allowed to sue, because his company was the one that was attacked or criticized, if not defamed. So, oh, I see. Live stream is taking a while to catch up. Oh, I was 2 minutes behind. There we go. Okay, good, it is working. So he was, if he's alleging he's defamed, well, he should be alleging that his company was defamed, not himself, because the company makes the products. He cannot claim injury from the company being defamed. But he's trying to figure out a way to do that. How long can a case like this go on? It's another 6 months or a year, depending upon the outcome of this motion to dismiss. If the judge feels that there's enough here to allow the case to proceed into the discovery of evidence, of further evidence, in which Mr. Romine will be allowed to ask questions of the defendant, and the defendant will have to answer them honestly and provide documents that are whatever exists. If I have documents and they're requested of me, I have to provide them. If that happens, it's going to take years. So this motion to dismiss is very important for Jim Sterling to keep himself out of an expensive court battle. Fortunately, it sounds like Mr. Sterling could afford the court battle, either because he's got lots of support from you guys and his community, or because he is a decent creator, and as a decent creator, he makes enough money to be able to do that. But yes, it could be a long time before this is adjudicated. How long do I think it'll be before this judge actually rules on this motion to dismiss? Any day. It could be tomorrow. It could be 3 months from now. Once in a while, you'll even see a judge sort of forget about it, and a plaintiff's attorney or a party's attorney will have to make a motion to expedite the decision. And they'll have to cite some reasons, too. You think we need jurisdiction reform? The judges and the courts are prepared, I think, to handle that. The difference is in America, in the U.S. system, they handle that through the courts, one case at a time. Only an actual case in controversy. You're not going to get a judge, you're not going to get progress on that without a legal reformation, and I don't think I see Congress making a law to change the way jurisdiction is handled. It could happen, but right now American politics are so deadlocked. I don't see the parties working together on an internet reform law. They really can't work together on anything, and it's only by the fact that we have federal agencies doing any job at all that the FCC, the FAA, etc., can even get anything done. Why did that dude love Ventura v. Kyle? Because he thought that the case supported his claims, and it does not. He thought it supported his claims because an out-of-state defendant was brought into the plaintiff's state, was dragged into the plaintiff's state by the long arm of the law to answer for a defamation claim. But that's actually not what it stood for. The defendant in Ventura v. Kyle apparently got sued and then allowed themselves to be subject to that jurisdiction and did not challenge that jurisdiction in that foreign court. Sorry for skipping any of your questions. There's a lot of them. Why would he pursue this under his own name? It may be because he did not have his brother. Is his brother? It's two brothers, right? It's James Romine and crap. Who else is it? No, that's not what I wanted. I wanted Vicky. One second. And Robert Thaddeus Romine. I'm assuming they're brothers. No defamation intended, guys. I'm assuming they're brothers. That doesn't mean anything, by the way. You can't just get yourself out of defamation by just saying you didn't. But also, what would be the defamation in brothers? But I think they're business partners in digital homicide, and if that's the case, they'd usually be 50-50 partners. They'd usually both have to agree on major decisions. I don't know what their operating agreement looks like, so I can't speak. So this is my educated opinion, but I think that either Mr. Romine, Mr. Jr., James Romine, does not have permission from his brother to file on behalf of Digital Homicide Studios, Or he really made a mistake and filed the thing under his own name, not realizing that he had to do it under DHS, and now it might be too late. Very, very probably is too late. Yes, how long till the judge dismisses it when he can stop giggling on the floor? Yeah, I agree. I don't want to scroll down the window, I want to scroll down the chat. The wheels of justice turn slowly. That is correct. That is very correct, everyone. Well, we've hit 2 hours, and I think that's about the most I can do with this. So I'm going to call it a night. Thank you so much, everyone, for watching. This has been a fun experiment. I'm going to edit this down to a shorter video and post that, but that will probably take me a few days because I've got apparently 2 hours worth of content to go through. So again, thank you very much for watching and joining me. Feel free to leave comments, send questions or messages. I love to interact with everyone. I'm Leonard French, your favorite copyright attorney. Have a good night. Well, I guess it's night for me. Have a good day for you if it's day. Have a good week. Have a good life. No, I don't mean that bad. I mean have a good like everything. I'm not like have a good life. Like get away from me. No, I just. Okay, stop.